Hello, everyone, and welcome back to the University. Today we start in front of Judge Meyer and we end in front of Judge Middleton. This case is Mark White versus Ashley Emery, and he's not actually suing her for anything that she did, but for something that her son did. Her son was driving and ended up rolling his vehicle, taking out this man's fence and some signs. Now, thankfully, her son is okay. That was first and foremost the concern. But now there's damage to this guy's property and someone has to be held responsible. So I hope you enjoy.
Next case we're going to take up is Mr. White and the Emerys. And so this case looks like a default was entered by me, actually. We have a number of judges. We rotate back in May. A default was entered in favor of Mr. White against the Emerys. And then now the Emerys are bringing their motion saying, this default needs to be set aside. We were never served. I looked in the file. There was service there, a substitute service against not the Emerys personally, someone at an address they were served. The Emerys are now telling me that based on did you get a chance to review all this, Mr. White?
Yep.
And so I'll hear from the Emerys first, and then I'll hear from you, Mr. White.
I believe at the last court hearing, the default judgment was out, and now we're being seen again for the original small claims. Is that correct?
I didn't think so. I thought it was the default set aside on this? I thought we were just. Oh, so the default was set aside on this.
No, this is a new case because.
Right, so we are back to ground zero. Mm-hmm. So you're right. And so we'll send you into mediation then.
Okay.
And
Your Honor, I had one more question.
yes.
I submitted a table of contents and some evidence that I wanted to be placed with the case, and when I checked online, the website, it had not been uploaded, and I brought that into the court 2 weeks ago. So I just wanted to make sure that that had been put into our file.
Okay, we'll check on that.
Thank you.
Do we have that? I mean, this was a confusing thing to me. I couldn't.
Yeah, it looks like it was filed.
Okay. Yes, it was filed.
Thank you.
On February 12th.
That is correct.
All right, you'll go into a meeting, put him in a breakout room and let him know that there's one other wants to mediate. Okay, so we're going to take up the case. Mr. White, can you come on the Zoom call there, please? So Mr. White, could you raise your right hand, please? You swear and affirm the information testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, so you're asking, again, the notice amount was it $2,600? Is that correct? And then how is it that the Emerys owe you $2,600?
Because their minor kid did a bunch of damage to my property.
Okay, so maybe you could expand on that a little bit?
Their son drove through my gate and rolled his truck and took out a bunch of fence lines and gates and landscaping and farm signs and stuff when he rolled his truck across my property.
What's your basis for the $2,600?
Just estimates I got from different people.
Did you submit those?
Yes.
I didn't see them. I saw some pictures.
Yeah, they were all submitted on the first go round.
Okay. And I have to see that. Okay. All right. Can you find those? Yeah.
If not, I can resend it real quick.
Your Honor, I wasn't able to find the estimates or anything submitted by Mr. White either.
I couldn't find it either, but the sequence of events that led to this being here now is kind of weird in the sense it was a default and the default was set aside and then all of that. How long ago did this happen there, Mr. White?
I think it was January of 23.
I see. Has your fence been repaired?
I have since repaired, yeah. I've done everything but the landscaping and the farm signs.
Okay. Is
I had
any of
to, I had
that
to
been
keep
covered
counseling.
by insurance or?
What's that?
Has any of that been covered by insurance?
Nope, it's all been out of pocket.
Okay. And then how much have you paid out of pocket?
Go over here. Oh, come on. So I've 400, 750, about 810.
All right, give me just a minute here. Ms. Have you filed those receipts?
What's that?
Have you filed any of the receipts that you paid out of pocket for?
No, I just checked. I put a checkbox on the listing of which ones were and which ones weren't.
Okay. So Ms. Emery, I'll hear from you. And I've read your stuff. And it sounds like Mr. Emery is not the parent of the person who did this. That's one issue. And then I'll hear from you. Could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. And then I'll hear you respond to Mr. White.
Your Honor, I don't deny that my son was the one that was in the accident. I did present a statement outlining my stance on that and a couple of RCWs that I believe pertain to this case. That's about where my stance is. My son wasn't living with me at the time. He was reported as a runaway on the 6th of January. The vehicle that he drove through Mr. White's fence was not in my name. My son did not have a license at the time, and my insurance company had dropped him because his license had been revoked. I tried to take the vehicle from my son, which is what actually caused him to run away. When I called Thurston County Sheriff to report the runaway and told them that he had taken his keys to the vehicle, I asked them if I could disable the vehicle. They told me that I could not touch his vehicle because the vehicle was in his name. And RCW 4612-755 states that a person under the age of 18 may not have a vehicle registered to them or be the legal owner of a vehicle. I did everything that I could to stop this from happening. My son didn't live with me at the time. The other RCW that I quoted was 424-190.
No, I see that.
Okay.
But I mean, did he have an established residence someplace else? Or was
He
just
did not.
on the run?
He was on the run. He was a runaway. I don't know where he was staying at the time.
Okay. Where does he live now?
He stops by here once in a while. He just recently got a job. And so he stays here on occasion. I never know when he's going to be here and when he's not. He's living up in Elk Plain, I believe it is, with a girlfriend part-time, and he's since turned 18, so he doesn't really tell me what he's up to.
How long had he been on the run when this happened?
I reported him as a runaway on the 6th of January. The accident, I believe, took place on the 23rd of January.
All right. Where are those things? Can you, what cause number do I go to 36A or 13865?
Yeah, there they are. They should be under just.
See, they're not. They're just, well, maybe.
Yeah, there's images.
Yeah, but these are just pictures.
Yeah.
I looked at all these.
Oh,
No,
yeah.
I was wondering about his estimates and so forth.
Oh, I don't see any estimates. No.
He said he did back in the original one. So the documentation, the estimates of your damages there, Mr. White, that's what I'm looking for, but can't find. You said you submitted those on the initial one?
On the first small claims back when. That I can resend it in 2 seconds if you want.
Okay. Send him a text.
Does he know how to use the chat?
Yeah, so the clerk here to my left is going to send you an email in the chat function. And when you get that email them in. And then I see Jamie's here from DRC. What happened? Were you here on the last case there, the Farians and McBride?
Yes, Your Honor, I was. They settled.
Okay, thank you. That's what because they were here and then they left. So, okay, thank you.
You're welcome.
So, Mr. White, I'm curious about some things. Occasionally, these cases come to me and you never know what you're going to get. I'm going to step off the bench because I'm going to do a little research on, I'm curious about something on the law, and I'll be back in a minute. But I guess one thing that I will say is if a judgment enters, it won't be against Mr. Emery. And so if a judgment entered, it would only again be against Ms. Emery because Mr. Emery is not, basically he's not the father, he's not the parent. And so, but I'll come back to that issue in a minute. I'll be back in a minute. Give me just a minute here. So he was going to send Mr. White. I have a different clerk here. Did you send those documents?
Yep.
Do we have them? I don't. I'm going to have the clerk direct me to where they are.
It is full estimate, and
Okay.
it is
I see it. So having reviewed the testimony, looked through, there was a number of pictures. I've reviewed all those. Mr. White submitted documentation of cost of repair damage. It was caused by at the time minor child of Ashley Emery. I stepped off the bench, ma'am, because what I wanted to look at is whether or not, first of all, there's not much dispute about what happened. Your child caused the damage. There's no question about that. The amount, and I looked at the, again, just given my experience, what's been submitted by Mr. White is frankly reasonable. And so then the issue became, again, the statute says when a child is, or parents are responsible or can be responsible up to $5,000 for damages inflicted by their children. And so what I was curious about, you'd said, well, he was listed as he wasn't living with us because he was listed as a runaway. So I kind of wanted to step off the bench. I looked for a little bit, did a little bit of research and consulted with one of my colleagues to determine whether or not the fact that if someone's at a runaway, whether that gets the parents off the hook, so to speak. And frankly, ma'am, I conclude that it doesn't. And even though that he may have been run away at the time, his residence is still with you. And so based on the law, that does make you responsible, which is unfortunate. I mean, you didn't do this, but that's the way the law is. And so the judgment, I will order judgment in favor of Mr. White. This principal will be $2,590, be a $50 filing fee, total judgment out of $2,640. And it's only against you, ma'am. It's not against Mr. Emery, as he is not the father of the person who caused the damage. And so that'll conclude the case here today.
Okay,
You can
Thank
get a
you.
copy of this off the district court website.
okay, thank you.
Okay, so this case is one that I have seen on a couple of other channels. However, I did decide to still include it today because other channels haven't included some of the comments that Judge Middleton was making outside of reference to the case. This is Chauvon Collins versus TJ Hall, and she claims that she loaned him $5,000 to pay some back child support, and he hasn't paid her back. Now, the part that I really liked and made sure to include here are the comments that Judge Middleton makes about the eclipse and the lovely conversation that he has with Ms. Collins about the eclipse while they're waiting for Mr. Hall to rejoin the meeting. So I hope you enjoy.
We took an eclipse adjournment. I said until 3:30. We have two parties that are here prepared to have a hearing, and we went outside with most of our staff and looked at the 96% eclipse. And live and learn, a 96% eclipse is pretty underwhelming. It did eclipse most of the sun, but not all of it, and it was still bright, a little bit like early gloaming in the early evening or when a thunderstorm comes, but it was not transcendent like I understand it is when you have totality. So it was a little disappointing, but we did get to see it. Let's bring the parties in and have our hearing regarding this matter. I'm a little underwhelmed. I'm disappointed. Too late now. Unless I get in a jet, head to Maine or something. Thank you for your patience.
Well, thank you for giving us the time to watch the eclipse.
It was a little underwhelming as far as I'm concerned. I was hopeful for more. We needed to be in the path of totality, I think, to get the full effect of it.
Yeah.
I've seen this circumstance before. So what we saw was a partial eclipse.
Still kind of cool though.
Yes. And we didn't have any cloud cover issues, so that was a blessing.
It was.
Mr. Hall has yet to return. How do I say your name? Chauvon?
Chauvon. Yep.
Chauvon. All right, let me give you a correct name.
Thank you.
Chauvon Collins.
Do I address you as your honor?
That's fine.
Okay.
Somebody asked me once, should I refer to as your highness? I said, no, your honor is fine. Someone this morning just called me Middleton, but in court, your honor is probably appropriate. Mr. Hall, as you saw, was here at 3. He was actually a couple minutes late, but he was here. There was a lot of camaraderie out in the parking lot, and people brought extra pairs of glasses, and it's a bright sunny day in the spring. So it was not without some merit, but
Yeah.
temperature
Oops, sorry.
Temperature went down and it got windy.
Yeah, it got a little bit eerie for a minute there.
Yes.
My kids and their friends, we all took them out of school early and just went to a friend's backyard. And I don't know, it's kind of cool that everybody's celebrating or having this moment in their own ways, but together.
Yes. Well, I don't know if Mr. Hall got mad and left or he's out in still observation mode. What kind of building are you in?
It's a warehouse that my friend converted into an event space.
Oh, it looks very interesting.
It's beautiful. Like you can't feel sad when you're here. It's just like a really happy place. And they have a big outside in the back that she thought would be good to watch the eclipse because there's no trees.
Where is it?
It's over in Schoolcraft.
Okay, I think I know where you are.
Wind and James, it's called. Maybe you've heard of it.
Yes.
Yep.
Yeah. Good afternoon, Mr. Hall. Can you hear me?
Yes, sir.
Ms. Collins, could you land in one spot? You're making me dizzy.
I'm sorry. I was trying to go where it's a little quieter.
All right, very good. All right, thank you all for your patience. We did a 20-minute, 18-minute eclipse adjournment, but we're back. This is the only case we have for the rest of the day. The title of this case is Chauvon Collins versus Timothy D. Hall II. You're Chauvon Collins?
Yes, sir.
And although you've got TJ, are you Timothy D. Hall?
Yes, sir.
Very good. As I indicated before we took a break, this is a claim for $5,000 plus costs. All right, I'm going to ask you to both please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, Your Honor, I do.
Yes, Your Honor, I do.
All right, this claim is pretty straight. You can put your hand down, thanks. I'll just read it. The reason for this claim are Chauvon Collins hired Timothy D. Hall Jr. for a construction project on 8/1 of 22. She paid him $10,000 on 8/1 with check 229. On Friday, September 30th, Timothy Hall told Chauvon he was going to go to jail for not paying back child support in the amount of $5,000. Chauvon gave him $5,000 cash on Friday, September 30th, 2022. He explained it would take too long to wait for a check to clear and he needed to be a cash loan. He further stated that once he had paid the child support, he could resume the work on her house that she already paid him for. Since that time, Chauvon has sent him numerous texts asking for her money back. To this date, he has not paid her any of the $5,000 she loaned him back in September of 2022. Is that your position, Ms. Collins?
Yes, Your Honor, it is.
Mr. Hall, what's your position?
Your Honor, just to kind of to sum it up, really, what is stated throughout what you just read is it comes as it's only a business transaction, and there's a lot left out. Even through the text messages, there's a lot left out, and this was an intimate relationship that kind of just I shouldn't have embarked on any type of business, anything in a relationship. And what had happened here is it's not entirely the truth of what's here, but it was a relationship that went bad. So I guess where I stand, Your Honor, is if Miss Collins needs this back as bad as she does, then I would just ask, Your Honor, that we can come to a fair agreement, just given my position of what payment can be fair to
A monthly payment. All right. Well, she says you had to have the money in cash. Did she give you $5,000 cash in September of 82?
Well, Your Honor, there's no actual anything stating. That's the thing. There's nothing there that states that I asked and said that any of that had to transpire.
Well, let me ask you a yes or no question. Did she give you $5,000 cash?
$5,000 cash, Your Honor.
All right, in $100 bills or what denomination?
In $100 bills, Your Honor.
All right, what was ostensibly that for?
Well, Your Honor, what was also left out of that was the arrangement was like half of what would be the final quote on taking on helping her redo this home. So it would have been $15,000, half of 30, which I and her had agreed to. So it would have been the 10 and 5, but we're on the 5 now that I owe her.
All right.
But this is all done, Your Honor, not businesslike. We were in a relationship.
Well, yes. And so there's no promissory note, there's no recording of this. It's $5,000 cash bills. Her version is you had to have the money immediately in cash to pay your child support. And the whole thing sort of doesn't pass the smell test. It can't be a certified check, it has to be cash. Did you use any of this $5,000 to pay child support?
Yes, Your Honor.
What county?
I would, is that the important thing?
No, I guess it doesn't. You acknowledge you owe the $5,000. I'm just gonna call it at that. This has an element that reeks of larceny by false pretenses. But it's not a criminal case, it's a civil case. She let you $5,000 in $100 bills and you didn't pay it back. So you're right, maybe I'm just curious and want to know what underlies this, but the basic fact is this is a civil case, not a criminal case. She doesn't have the burden of proof beyond a reasonable doubt, it's beyond a preponderance, and you essentially acknowledge that you owed the debt and looking for a repayment plan. If I simply enter the judgment, you would have 21 days to pay this, or she can pursue collection remedies like garnishing your wages or seizing property or that sort of thing. If we can come to a repayment agreement where you make a monthly payment, then that would preclude her from garnishing or taking other collection remedies. How much can you pay on this?
Right now, in my position, Your Honor, I don't make buku dollars. I'm not a high dollar guy. I'm being honest here if I tell you that I'm literally only looking to possibly right now, as things get better, $50 to $100 a week at most.
All right, well, I was gonna go with $250 per month. Is that acceptable, Ms. Collins?
Yes, I'm just curious if the payments aren't made or if he makes a couple and then no more payments after that, what happens?
Then what you do is you file a hearing for a discovery hearing where he's compelled to come to court and provide information about his bank accounts, his social security number, his employment, any vehicles he owns like snowmobiles or ATVs or wave runners or fishing boats, things that could be seized to pay the debt. So if he doesn't pay, then you would pursue a discovery subpoena where he'd be compelled to come physically to the courthouse and answer a series of questions. All right, I find after trial that the defendant owes $5,000, $83.50 in filing fee and $54.14 in a process serving fee for a total of $5,137.64. And in payments of $250 per month. This will take a little less than 2 years to pay this off. And Judge McManus, who preceded me, would try to get things paid within 2 years, starting May 1st. Mr. Hall, are you still on Maple Lane?
Yes, Your Honor.
Where are you employed?
I'm subcontracting right now for.
All right. And things pick up in the summer.
Yes, Your Honor.
All right. Ms. Collins, are you still at Cully's Trail in Portage?
Yes, Your Honor.
All right, I find for the plaintiff by a preponderance of the evidence that the defendant owes that amount, which was a loan which was not repaid. I don't need to get into what he did with it. In fact, it might be dangerous for him. I'm not sure whether there's a false pretense here or not. I guess I don't need to get into the contract for construction. Simply this: court cost, bring it to $5,137.64, payable at $250 per month starting May 1st. You should make the payments directly to Ms. Collins, not to us at the court. I would suggest you use a certified check or money order so you have a receipt of each payment. Keep track of it. You can pay it sooner if you get a big tax refund or win the lottery or something. You pay it off to bring it to close. But as long as you continue to make those payments, she can't do a garnishment. If you fail to pay, she can file a motion to set aside the repayment agreement and pursue a garnishment or seizure of assets, including work tools, stuff like that. So that's very unpleasant. So $50 a week, give or take, is $250 a month. All right, so that concludes this matter. We'll send a copy of this to each of you at your mailing address. First payment is due May 1st.
So
All
he
right.
mails it to me at my home?
Correctly, directed to you at your home.
Okay,
You both need to keep track of the total.
okay.
But essentially, it will take about 21 months to pay this off. 250 times 10 months is 2,500 and 2,500, and then the balance of 137.64 plus potentially any interest. All right, this matter is concluded. Mr. Hall, you got it. It just sort of is what it is. Best of luck to both of you.
Thank you, Your Honor. Have a good day.
Thank you.